Good afternoon, my name is Ronaldo Hilton, the Chairperson Designee of the New York City Loft Board. Welcome to our April 18th, 2019 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversion of interim multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residences that comply with the minimum standards of safety and fire protection are stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board rules. We first turn our attention to the minutes from the February 14th public meeting. Are there any corrections or comments to these minutes?
I do, yeah.
Mr. Clark.
I believe I'm actually not listed as being present, is that right?
Oh, that's a mistake.
Thanks.
Sorry.
So that will be changed to
Yeah.
include Mr. Carver's present. Any other comments on the minute? Is there a motion then to accept it with that one change? Mr. Carver, second. Mr. Barrows. Oh, I'm sorry. Ms. Ryan, could you please pull the board members?
Mr. Carver?
Yes.
Mr. Borowitz?
Yes.
Mr. Roche?
Yes.
Mr. Burnett? No, Mr. Henderson. Mr. Delaney?
Yes.
Ms. Torres?
Yes.
Ms. Roslin?
Yes.
Chairperson Hudson?
Yes.
That's 7 in favor.
Thank you, Ms. Ryan. Vote, we now turn attention again to the minutes from March 6th, 2019 public meeting. Are there any corrections or comments to those minutes?
Yes, I think same issue for me, at least, I think.
Were you here?
I was there.
All right, Mr. Delaney.
Yeah, on page 1, Chief Jordan, the third paragraph, is giving Mr. Roche credit for keeping him well informed of the activities and products of the Loft Board. I didn't know what we produce.
He actually said it because I double checked. That was what he said. So
But
I guess orders.
I was thinking progress. Are you sure you didn't say progress?
I'm positive, but I can change it if you want.
But, I mean, would either make sense? Or, I guess.
Well, I think he was talking about the orders. That's what I was
Work
thinking.
product.
Yeah.
Okay.
But yeah,
We give Mr. Roche false credit. Okay, so it was said, so we leave it. Okay, is there a motion then to accept the minutes? Mr. Roche, this should be you. Mr. Roche. Is there a second, Mr. Carver? Ms. Ryan?
Mr. Carver?
Yes.
Mr. Borowitz?
Yes.
Mr. Roche?
Yes.
Mr. Delaney?
Yes.
Ms. Torres?
abstain because I was absent.
Okay. Ms. Roslin?
Yes.
Chairperson Hilton?
Yes.
6 in favor, well, that's 1 abstain, 2 absent.
Thank you, Ms. Ryan. Ms. Balsam will now present her Executive Director's report.
Okay. So my first piece of news is actually a very sad piece of news. Our assigned HPD inspector, Sumit Sood, passed away on April 5th. He worked very hard to protect all of our stakeholders, and he will be missed. Discussions are underway for a replacement. We're doing the best we can with the complaints that are coming in. Fortunately, most of the complaints that have come in so far were things that we could route to DOD. In terms of amendments to the loft law, those are still pending. In the Assembly, the bill went through committee and is considered on the floor, but there is no companion bill in the Senate yet. So that's still in committee in the Senate. The unofficial Loft Board revenue for March was $7,877. In litigation, we received 2 new cases. The first is Meserol AB 8391 Equities Corp. Versus Rusin. This is the tenant is in housing court with the owner. The owner brought a holdover, and the tenant is asking the housing court to stay proceedings pending the Loft Board's determination of the tenant's protected occupancy claim. And I think that the court stayed the holdover proceeding pending our decision. And the other one is Lori Sullivan and Paul Wilson versus New York City Loft Board. The tenants challenged Loft Board order number 4837, which was a rent overcharge case. The board found that their rent is $2,598 a month. The tenants argue that their rent should be $2,382 per month. And that's all I have.
I had a question, Elaine, about one of the documents that you had sent us, the mandamus order from last month in 99.7. I guess one question is, did the law department oppose the application here?
Yes.
Okay, and on what grounds?
So I can send you the papers, but basically saying that mandamus, whether or not to reconsider a case is discretionary on the part of the Loft Board. That the board itself has discretion as to whether or not it wants to grant a reconsideration.
I see. And we lost that argument, I guess.
No. Which one was quoted?
The petition is granted, it says.
We had 2 of them, so I'm getting them confused. So that was not the reconsideration, so then that was the,
Okay.
right. It was the appeal. It was the, to make a determination about the sales of rights. Yes, okay.
And,
Right, so take back everything that I said, because I was thinking of the wrong case.
Well,
I
I'm actually
apologize.
I'm glad you mentioned the other one, because that's kind of interesting,
That was the other decision.
legal arguments, but
Yeah,
this is a little different.
yes. So it was to make an administrative determination on what could be second sales of rights.
Okay, and we oppose the application for mandamus here also?
Yes,
Okay, and we lost.
yes.
Okay. What were the grounds for the opposition
For our opposition?
for mandamus, yeah?
Oh, because it's so complicated. So we have a lot of pending cases with this particular entity. So I think we need to discuss it in executive session or offline,
Okay.
okay? But I can certainly send you the papers.
My concern isn't necessarily specific to this party, but when a court actually grants mandamus, something has failed on our part, I think, that it actually got that far. And it's very upsetting to actually see this happen. And I think it undermines the credibility of the board in the courts when we see this. And I'm just wondering, what steps can the staff take to avoid being in a position where even an application like this is made in the first place, let alone lose it.
Decide things faster. I mean, that's really,
Yeah.
that's what we need to do is decide things faster.
Yeah, and I'm bringing this up because I was copied on 2 letters to the staff, and I think to you, threatening mandamus, basically. So, I don't know what the merits of that claim might be, but I guess when the staff gets a threat like that, how does it get evaluated? Is anything being done about that? Is it serious? But I really think it's a bad idea to be having these claims made against the board and then losing them. I mean, it really upsets me to see a case like this. And I think it must upset you too. But.
Well, I think the judge was wrong, but what can I say?
Yeah.
I mean, so, yes, we take threats of mandamus seriously. Obviously, we take mandamus actions more seriously. If we jumped every time somebody threatened mandamus, then everybody would threaten mandamus, and we would be right back where we are. So, we evaluate and see, is this something that we want to do sooner rather than later, and figure out which way to go.
What are the standards that you would apply as to whether or not to actually take it seriously?
Well, for one thing, how long the case is pending. Right, so how long has the case been before us? Where is it in the process? Is there a good reason why we haven't done things sooner rather than later, assuming that's the case, which was not the case in this particular, in the 99 Sutton one.
Right. Is length of time the only factor?
No.
It was the merits of the...
Well, there could be other things happening also as somebody, is there a pending eviction? I mean, there are a lot of different things. It also depends on the kind of case, too. So,
Mr. Corp, are you suggesting that maybe the board should be made aware immediately upon receiving such a document with a potential threat in it, or?
No, I'm just trying to think about how we can avoid being in court with a claim that we're not doing our job and then losing that case. I just think it looks terrible.
But if you don't even know about it, I guess is what I'm just trying to say, is if some of the board members, or maybe all of the board members, for whatever reason, aren't even privy to the issue.
I mean, even if I knew about it, there's nothing I can do about it. We have only so much manpower.
Right.
I bring this up because during the annual report, we mentioned that, some of our limited resources to do cases were going to be sidetracked to do other things. And I said, well, gee, what is that going to mean for the backlog? And, here we have a mandamus that we lost. I happen to know about 2 more threats. Are there other threats out there? I don't know. But are we going to wind up with cases not being processed? And how long is too long in staff's view?
Let me just respond. What we have right now is that we have a system in which we try to do cases by the filing date, the oldest cases first. However, there are other priorities that we do consider, meaning that an application for access, an application for alternate plan, an application for harassment, an application, like those applications we do try to do first, because those applications directly impact one side and directly impact utilization and the furtherance of the goal of the Loft board. There are other things that we have discussed internally about the backlog, and we are exploring other ways to assign cases and try to deal with the issue. We have not come up with a final solution to the problem, but we have considered it and we are talking about it. I have considered about how to a different distribution of cases and how to deal with that, so that the next person online is actually working on the very next case, as opposed to just assigning the cases to the individual attorney and then dealing with that, because then one attorney may be further along in their list than the other attorney. So we are exploring ways to deal with it administratively to address the
life safety issues be one of the factors to look at a case more
Certainly,
quickly?
yes.
Yeah, because I just point out, that's one of the issues that was raised in the threats for my neighbors that I saw. All right, I mean, that's all I had on this issue.
Any other questions, comments, Ms. Bolton? Thank you, Ms. Bolton. Okay, so our next thing on the agenda is a vote on the cases. We have the appeals and reconsideration calendar. There are 2 cases on the appeal and reconsideration calendar. The first case is an appeal. That is the applicants Peter Malerba, Elizabeth Malerba, Datia Mormon, Karen Dunn, Elizabeth Zimmern, Kimberly Mongello, Matthew Scotch, and Maureen Newman. That's 255 18th Street in Brooklyn. The docket number is AD0086, and Mr. Clark will present this case.
Thank you, Chairperson Hilton. Board members, on September 18, 2013, the Department of Buildings issued a residential certificate of occupancy for the building. On January 22, 2015, the owner of the building registered 25 IMD units pursuant to Section 2815 of the MDL. On December 27, 2016, tenants filed an application seeking a finding that owner is not in compliance with the legalization deadlines because owner did not complete all the work in the legalization plans. On February 1st, 2017, the Loft Board staff issued a determination rejecting tenant's application and explaining that pursuant to Section 645B3E of the New York City Charter, the building's 2013 residential certificate of occupancy is binding and conclusive upon all agencies, including the Loft Board, unless it is set aside, vacated, or modified by the BSA. On March 20th, 2017, the tenants filed the appeal challenging the determination. On April 6, 2017, owner filed an answer to the appeal. Pursuant to 29 RCNY Section 1-07.1(1)(d), in reviewing an appeal from a determination by the Loft Board staff, the Loft Board must consider whether the facts found are supported by substantial evidence in the record and whether the law was correctly applied, but may not consider any evidence not presented to the board or the hearing officer unless good cause is shown as to why the evidence was not previously available. Here, tenants argue the application does not seek to challenge the certificate of occupancy. It only seeks a finding that owner is not in compliance with its legalization requirements under the Loft Law and the Loft Board rules. While the Loft Law and the Loft Board rules require the owner to take all reasonable and necessary action to obtain a certificate of occupancy for residential portions of the building, the actual construction work necessary for achieving that goal is not the subject of any Loft Board rule. The Department of Buildings has the sole discretion in these matters and is subject to review by the BSA. While it is known that on November 20th, 2018, the BSA voted to revoke the 2013 certificate of occupancy for the building and issued a resolution on February 15, 2019, the certificate of occupancy was in full force and effect at the time of the determination on February 1st, 2017. Thus, with respect to the determination and the record before the staff on February 1st, 2017, the Loft Board staff correctly found that the certificate of occupancy was binding and conclusive on the Loft Board. The subsequent revocation of the certificate of occupancy was not part of the record. For the reasons stated, the proposed order before you today denies the appeal.
Thank you, Mr. Clark. Do we have a motion to accept this case? Motion to accept.
Oh, come on.
Mr. Delaney, thank you.
You didn't call for a discussion, just...
We will. I need the case to be accepted first for discussion.
The motion.
The motion is on. Would you like to second? Thank you, Mr. Barbers. Is there any comments or discussion on this case?
Yes, I would just comment that it's rare, but not the first time that a certificate of occupancy has been revoked in a loft building. And Mr. Clark, in his summary, did not include the fact that the actual conclusion reads, the appeal is denied without prejudice to the tenant's ability to refile the application, requesting a finding of noncompliance with the legalization deadlines.
Thank you. Any other comments?
I would just add, I do find it, as an architect, very disturbing that the C of O was revoked. And so that last sentence that he just stated out loud is an important part of how I'm voting and in the future.
It's a good thing that it was revoked because now they have to file it in the proper manner.
Yes.
Right, so it was just given to them without any actual legalization of the building. And now it's been revoked, and now the owner has to go through the process of filing and bringing the building up to code under hopefully more observation from the DOB. That's the general gist of this, right?
Yes. You're correct. Thank you, Ms. Roseman. And Ms. Torres. Any other? Yes, Mr. Chair.
I just want to mention, I have as an officer of the fire department, I've had reason to be in this building on a rather extensive matter, and as such, I think it's going to be appropriate if I abstain from voting in this building. I don't want to give the appearance that I am either for the owner or against the owner, or for the tenants or against the tenants. So I'm going to abstain.
Is
Okay.
it that bad?
Excuse me?
Is it that bad?
No, my statement wasn't meant to say that it was bad or good or otherwise. It was just meant that, I've been to the location and I don't want to give any appearances of my vote being taken out of context as, being improper.
Well, I mean, certainly we give you that opportunity, to do what you just don't think it's, you have to.
My concern simply is that I don't want either the owners or the tenants, some of who I actually came in contact with during our operations there to have any reason to feel that my opinion may be skewed
Understood.
one way or the other.
Understood. Thank you. Mr. Roche, any other comments? Ms. Ryan, could you please poll the board members?
Mr. Parker?
Yes.
Mr. Barwitz?
Yes.
Mr. Delaney?
Yes.
Ms. Torres?
Yes.
Ms. Roslin?
Yes.
Chairperson Townsend?
Yes. Did
You have to
poll
ask
Mr.
him, and
Roche.
he has to officially say it.
I abstain.
Oh, I'm
Yeah,
sorry.
Just ask, just ask him.
Mr. Roche?
Abstain.
Okay. Okay, so 1, 2, 6 in favor, 1 abstention, 2 absent.
Thank you. The second case is a reconsideration case, and that the applicant there is Thomas Spring, 72 Warren Street in Manhattan, docket number R0370, and Ms. Paulson will be presenting this case.
Good afternoon, board members, Chairperson Hilton. The application requests reconsideration of Loft Board Order number 4817. In that order, the board partially granted the tenant's application and found the owner unreasonably interfered with the tenant's use and occupancy of his unit because the owner departed significantly from the estimated time schedule to perform legalization work. The Loft Board denied tenants' other claims of interference based upon some sheetrock that was put on the west wall and a violation of the tenant protection plan, and that order was mailed on October 24th, 2018. On Friday, November 23rd, 2018, at 10:10 p.m., the Loft Board received a reconsideration application by fax, and on Monday, November 26th, 2018, the Loft Board received an original and 4 other documents of a second but different reconsideration application, as well as the application fee. The proposed order denies reconsideration because Loft Board rules require reconsideration applications to be filed within 30 calendar days after the mailing date of the determination sought to be reconsidered. The rules further provide that applications are considered filed on the day they are received by the Loft Board during business hours, which are 9 a.m. to 4 p.m. Monday through Friday. An application is not filed until the Loft Board receives the application fee. Here, the tenant had until 4 p.m. on November 23rd, 2018 to file his reconsideration application. Both the fax and the paper application and the fee arrived after this deadline. We are going to change the end of the order, the last paragraph. We're moving up the footnote, so it's going to read, as to the second application, while the correct number of documents and the application fee were filed, that application also arrived at the Loft Board's office well after the 4 p.m. deadline on November 23rd, 2018. Therefore, it too is untimely. And then the citation to the case, matter of J.M. Hoyt, etc. Furthermore, not all of the documents were the same. Some exhibits in some of the documents were missing pages.
Thank you, Ms. Boston. Is there a motion to accept this case? Mr. Carver, is there a second? Mr. Roberts. Any comments on this case? Discussion?
Mr. Chairman, while I certainly don't make it a point to go around and knock on Loft building doors, unfortunately I had an official capacity with the fire department in this building, and I'm going to abstain from voting in this case also.
Okay, thank you. Any other comments, discussions? Mr. Scott? No.
Yep, I'm sorry. In reflecting on this case and the prior case, it occurs to me that I think the more appropriate way to handle this case would have been to have rejected the application rather than denying it because it was untimely, which is what we did to trigger the administrative determination before. We said, in the prior case, we said, building has a C of O, therefore we reject this application. Here, we're denying the application. It seems to me that the circumstances are the same as the first case, which only occurred to me as we were covering the first case.
Well, I don't think the circumstances are the same at all. I mean, the first case asked us to do something that was outside our authority, and the second case did it. So I don't really think it's the same at all.
We're getting a lot of response from the staff in the public session. So,
No, I agree. Why?
see, technically, they're not supposed to answer
Yeah,
questions.
No, but it's a good point then, if, in order to reject it,
The history.
there's an assumption that it's been accepted.
Let me explain my angle on this, which is we used to get reconsideration applications that were untimely, and the staff would say, well, but even if it were timely, we'd reject it for thus and such and thus and such. And it struck me that, or if it had been filed timely, we would have accepted it. But if the answer is that it's untimely, boom, that should just end the matter, rather than have further discussion on the merits.
Which we haven't.
Right, which in this case was not done. But why would we, if it's untimely, why are we denying it rather than rejecting it? Just a procedural thought that occurred to me.
Well, I certainly want the input of the staff, so we should go back into private session for maybe 5 minutes just to resolve it so we can move the case.
Does anyone want to clarify? Can staff clarify this?
Can we
Without,
in private session?
no, it can be clarified. Do you think clarification here would best be done in private session, or has to be?
Yes.
Adjourn. Okay, we're back on the record. Any other comments on this case? Okay, then we'll ask Ms. Ryan to please poll the board members.
Mr. Carver?
Yes.
Mr. Horowitz?
Yes.
Mr. Roche?
Abstain.
Mr. Delaney?
Yes.
Ms. Torres?
Yes.
Ms. Rosalind?
Yes.
Chairperson Hudson?
Yes.
6 in favor, 1 abstain, 2 absent.
Thank you, Ms. Ryan. So there are 6 cases on our summer calendar. They're voted on as a group. We're going to remove case number 7, vote on it separately. So the other 1, 2, 3, 4, 5 cases are read right now. They're going to be voted on as a group. Case number 3, Noel Johnson at 476 Shropland Street in Brooklyn, docket number PO0092. Then Pamela and Christopher Brown at 255 18th Street in Brooklyn, docket number TA0230. The 5th case, Tom Soper, 365 West 36th Street in Manhattan, docket number TH0216. Then number 6, Chiara Diva Patilla at 365 West 36th Street, Manhattan, docket number TH0217. And tenants of 210 Barrett Street, 9 White Street, aka 210 Barrett Street in Manhattan, docket number TR1360. Is there a motion to accept these?
Mr. Chairman?
Yes.
Can I ask that case 4 be pulled out and voted on separately? 255 18th Street. I'm sorry, I didn't catch it.
Sure, can I just make a note of that? I don't have to read it.
No, you can't.
All right, so we will also take out case number 4 voted on separately. So the cases that we're going to vote on as a group are number 3, number 5, number 6, and number 8, and those we have already read. Are there any comments on these cases? Oh, excuse me, is there a motion to accept these cases? Mr. Carver? Is there a second? Mr. Bowers? Any comments on these cases? Ms. Ryan?
Mr. Carver?
Yes.
Mr. Horowitz?
Yes.
Mr. Roche?
Yes.
Mr. Delaney?
Yes.
Ms. Torres?
Yes.
Ms. Rosalind?
Yes.
Chairperson Hudson?
Yes.
7 in favor. 7 in favor, 2 absent.
Okay, case number 4, Pamela and Christopher Brown, 255 18th Street in Brooklyn, TA0230. Is there a motion to accept this case? Mr. Carver, is there a second? Ms. Rosalind, is there any comments on this case? Mr. Rose, you have a comment on this case?
Thank you. Do you have a comment on the floor?
I'm going to abstain from this one as well for the same reasons. It's the same address as the first case that we did.
Okay, thank you.
Another point of clarification, so as I asked earlier, this then goes back once the
You need to have
application,
an opportunity to...
Yes.
Yeah.
and it clearly states that in the docket.
Hold on. Yeah, it's dismissed without,
Yeah.
it's dismissed without prejudice.
Thank you. Any other comments?
Mr. Carver?
Yes.
We're ready?
Yes. Ms. Ryan?
Okay. Mr. Carver?
Yes.
Mr. Horowitz?
Yes.
Mr. Roche?
Abstain.
Mr. Delaney?
Yes.
Ms. Torres?
Yes.
Ms. Rosalind?
Yes.
Chairperson Hudson?
Yes.
7 in favor, 2 absent, none against.
Thank you.
6 in favor, 1
Oh, I'm sorry,
abstain.
6 in favor, 1 abstention.
Okay, the final case is tenants off 255 18th Street. That address is 255 18th Street in Brooklyn, and that docket number is TM0091. Is there a motion to accept this case? Mr. Carver, is there a second? Thank you, Ms. Rosalind. Any comments?
Yes, I'm going to vote no on this case. This is one of the cases where I believe the terms of the stipulation are not something that the Loft Board should turn a blind eye to, neither accept nor reject.
Thank you. Yes.
Again, Mr. Chairman, we have that address, 255 18th Street. I had to operate this building as an officer of the fire department. And I believe I should abstain.
Okay. Are there any other comments? Ms. Ryan?
Oh, wait, I was going to make a comment.
Sure.
So I'm going to vote, can I say what I'm going to vote?
Yeah.
I'm going to vote yes, but it's because I believe there's going to be a rigorous Department of Buildings process now that the C of O has been revoked on this building. That might, change, it's just going to go through a rigorous process. So I'll leave it at that. Thanks.
I'm going to say that I'm going to vote with Chuck here because I think there's a potential to set a precedent that is not, in my view, in the spirit of what we are supposed to sort of uphold and value.
Okay. Are there any other comments in this case? Ms. Ryan?
Mr. Garber?
Yes.
Mr. Barowitz?
Abstain.
Mr. Roche?
Abstain.
Mr. Delaney?
No.
Oh, well, I changed then. I'm allowed to change my vote.
You
No.
haven't voted yet.
You haven't voted yet.
You haven't voted
You
yet.
haven't voted yet. We haven't called yet.
Okay, sorry.
Mr. Delaney, no.
No.
Ms. Torres?
No, sorry, it will go through a rigorous process, but I'm not going to be.
And Ms. Russell?
No.
Chairperson Helton?
Yeah.
2 in favor, 3 dissenting, 2 abstaining.
Okay, this motion is not passed. All right. Move on. There are 2 cases on there's 2 cases on the master calendar, and those 2 cases are being tabled. So there will be no vote on case number 9 and number 10 at this board meeting. So in this case, the board will then continue its discussion on the proposed rule changes, and Ms. Balsam will lead this discussion.
So at the March 6th meeting, the board had asked us to do some research about lease provisions surviving if the lease expires and isn't renewed and the tenancy becomes a month-to-month tenancy. And so Ms. Cruz is going to present some information about that.
So, the board asked the staff to research the question about whether a holdover tenancy, meaning a tenancy that continues after the lease expires, continues on the same terms and conditions as those contained in the original lease. My research is ongoing, but I wanted to update you about my findings so far. It is a general rule in case law that a holdover tenancy continues on the same terms and conditions as those contained in the original lease. I read a 1975 case that holds that. However, it's not an absolute rule.
Ms. Cruz, could you just speak a little bit?
Sure. It's not an absolute rule. The same 1975 case sort of lays out exceptions to this rule, including that the acts and conducts of the party negate the existence of the original lease. When the lease term is inappropriate by reason of changed circumstances, and when the circumstances tend to refute the party's intent regarding the continued application of the lease term, which is not an essential element of the landlord-tenant relationship. So I am now in the process of researching what that language means. I found some cases to sort of interpret some of it, but I'm not ready to present to the board that right now, under our circumstances, that we are required, or that the board is required to exclude all others that were there on the effective date of the law pursuant to this general rule. Because the cases do lay out these carve-outs, and without fully understanding what they mean, I am not prepared to tell the board that this rule is applicable here to our situation. So research is ongoing, and I'm hopeful that by the next board meeting, I'm going to have the staff's recommendation on this issue.
What's the name of the case, Martha, and what's the court that it's from?
It's Transit Drive-In Theater versus Outdoor Theater Caterers. It's an appellate division case, and it's a 1976 case that sort of lays out these three things.
Can you just email that?
The case?
The
The
site.
fire case?
Yeah.
Okay, sure. It's a case in which the original lease talked about that the parties would not be responsible for each other's negligence, and the court rejected to apply that. And that was part of the original lease. So I'm interested in sort of talking, in researching more about these carve-outs, about why.
I had sent some case law over.
I did, and I read.
You have it?
Yeah,
Okay.
I read the original, the City of New York versus Pennsylvania Railroad. That's one of the cases, the 1975 case that I talked about, which lays it out in general rule. It references back to a 1903 case, which was interesting to read.
Okay.
Sure.
Okay,
I'm sorry. In the minutes, there was also some, and I can't remember which one of you, but there was going to be somebody was going to take a look at the question of the ability to cure a primary residence allegation, rent stabilized proceeding. Have you had a chance to do that? I know you guys are short-staffed. I'm not out to bang people's head on.
I have a general answer, but I would prefer to wait to answer the question completely.
So you are working?
I am working on
Yeah,
it,
okay,
yes.
that's all.
okay, so that brings us to the redraft of section 209. So we'll keep in the placeholder for prime lessees with a lease in effect being protected occupants to the exclusion of everyone else if applicable. We'll leave that in as section 2. Section 4, we redrafted, staff discussed, and we redrafted, and the proposal that we had, the issue which we discussed at great length on March 6th was if we were going with primary residence, which seemed to be the way the board wanted to go, when would the tenant have to prove primary residence? And so we had different dates. Is it the effective date of the law? Is it on the date the application was filed? Is it the date the record closes? Is it something else? So the effective date of the law we talked about, and it seemed to us that the issue about surrounding the effective date of the law is whether or not there was landlord consent. So we tried to separate out the consent element from the overall rule, and we are taking a position, and again, it's a draft, you'll tell us what you want, but I kept coming back to the question of who are we trying to protect, and everybody kept asking us, well, who are we trying to protect, who are we trying to protect? Well, we're trying to protect, I came to the conclusion that the people we're trying to protect are the people that are there. And whether or not they were there on the effective date of the law goes to whether or not they need to prove owner consent to them being there. And that's a separate issue apart from whether or not they deserve protection now as of the application date. So we came up with the application date through the date the record closes. And that's what we have in the draft. The only issue that we have with that is this rolling discovery issue. So if it's the date the record closes, what happens if somebody testifies and then the record closes? Could be a year later because the record was reopened for some reason or whatever. There's usually briefs that are filed. So, you know, staff threw out all kinds of ideas of what we could or couldn't do. So we could change this to reflect the process on the ground, to say on the date of the application and through the last date that that person testifies if there's a hearing. So that's what we're thinking. We would like to get your thoughts on that, and then of course we can redraft again. So big picture, separated out the consent issue, and then in terms of proving primary residence on the application date, through either the date the record closes or the last date that the person testifies at a hearing. So that's what we have. So thoughts, please.
All right, so landlord consent is not required if the occupant is in occupancy on the effective date of the law?
Yes.
Okay, so that's the old rule and the new rule, that's not changing?
Correct.
Okay, but are we changing something about the period between the effective date of the law and the application date? Is that what's changing?
Yes. Well, the board had talked about inserting a primary residence requirement and when that should be.
So that's only, under the proposal, that would commence as of the application date only?
That's what we decided. That's where we came out when we were having our discussions. I mean, nothing's written in stone. You can convince us of, you know, I mean, we're the board, you'll decide. But it seemed to us that if the question is who are we trying to protect by this primary residence requirement, the people that we're trying to protect are the people that are there. Those should be the protected occupants, and they should be there as of the date that they are applying to become a protected occupant. So it's sort of, I'm falling back from my original position because I've been thinking through it and saying, well, maybe what we're trying to address is people that are filing and then moving, which is really what we're trying to address, although we did have one person that moved in and filed. But.
So this would, in essence, help the person who is in occupancy on the effective date of the law, moves and then comes back?
Well, it could, yeah. It could.
Right, that's-
I mean, should we care? I don't know, if they're there now, I mean, it's as if, right, they are somebody who came back after the effective date of the law.
You would think you would need landlord consent then, because you kind of waived your status by leaving, I would think.
Something to consider.
Yeah. I'm opposed.
Not surprised.
You mean the fact that they would move out and move back in, if that's what you're...
At least on that narrow aspect of what we're going to talk about. We have to talk about more about what happens later.
Well, I think it's such an obscure possibility, but...
I mean, any break.
Yeah, I mean, it's... You know, it's just so difficult in this city to live, period. And the fact of denying somebody this small little technical ground makes it very difficult for me to accept.
It's a car, any break.
Sure.
Well, I don't know that we would be denying them, though.
Well, is that what that's what you would deny Is that correct or not?
Absent landlord consent, yes.
Okay.
Okay, anyone else?
I had written to Ms. Balsam that I had not had time to review this, so I'm not going to comment.
Anything to say?
Can we go into what you were describing more the data that here, that they testify?
So let's assume it's an application, and I think it was, maybe it was both sides of the attorneys gave this example of where they had a case where it was several tenants that had applied together, and there was one person where there was an issue of primary residence, right? So let's just carve out that one person, right? So for that person, the board, under what I'm proposing, right? So the board would protect that person if the person proves that the unit was their primary residence on the date that they applied, and then that person testified at the hearing, right? So
The oath hearing.
at the oath hearing, right? So whatever the last date that person testified on, so they would have to prove primary residence through the date they filed the application and the date that they're testifying at the oath hearing. Because if we go all the way to the date the record closes, that could be much further along, and you don't necessarily want to have to do more fact-finding after people have written, after both sides have submitted their briefs, right? So, you know, we threw around the idea of, well, maybe they could put in an affidavit saying that nothing's changed, but then shouldn't the other side have to have an opportunity to cross-examine that affidavit? And so that's not going to work. So that was just an example. So we felt that if the person is there and the person is testifying, that would be a good cutoff date.
And that's assuming all other proof has been,
The 12 consecutive months.
Well, that's coverage, that's separate. This is just to protect this person.
right, has been submitted before the date of testimony. That's the,
Well, they'll be submitting, I assume that they'll be submitting proof as they're testifying as well, right? So if you're the person that's living there, you're going to have your bank records, you're going to have your whatever,
Right,
your
I
bank
guess
records,
that's
your
my
taxes,
question. So
whatever,
that-
that'll come in to the records through your testimony.
that happens concurrently.
Yeah.
So that time frame, that's essentially, that would cut down, that would be approximately, well, you can't put a date.
Well, I mean, you
It
know-
might be a year.
Well, it could be longer, but let's take the 2010 law, okay? So the law, so the window period is 2008, 2009. So under the prior proposal, they would have gone all the way to the window period if it was coverage and protected occupancy. Under this proposal, yeah, they'd have to prove some stuff about the window period for coverage, but for protected occupancy, they would have to prove primary residence only as of the date they filed the application, which could have been 2017, right? Let's assume they got it in at the last possible second, June 15, 2017, prior to 4 p.m., right? And up until whatever date it is that they testify at oath. So, you know, how long that would take is going to depend on how many people are in the action, how many settlement conferences there are, discovery, all of that. But it puts it's a shorter period, a more finite period. It may not be, you know, it could be 5 years. It's possible
Because they might end up in a couple.
for a long time. Well, they might, you know, there could be a lot of settlement conferences, there could be motions back and forth, you know, there are all kinds of things that could cause delays. So it could be a longer period of time, but it will certainly be shorter than from the window period. Right, it cuts off all the time between the window period and the application period.
So now, if I get this right, you're really defining coverage IMD unit as what the bill takes care of the unit, the physical space,
Right,
and the primary occupant is separate,
protected occupancy.
protected occupant, protected occupant is completely, you're clarifying the way to separate it. I felt like it was muddied where,
Well, the whole exercise is to try and make it clearer.
okay.
That it has gotten muddied and we want to try and make it clearer.
Okay. And the idea being I like that it's less time, not 10 years of approving. That's where we were last time we talked.
Yes, yes,
It's
and
like we were going beyond 7 years of tax, like
we
we're going.
took that very seriously. I
Okay.
mean, that was a real concern that the board had, and we discussed what would be a good way to deal with that.
Yeah.
And so this is what we came up with. We think it's fair.
Uh-huh.
So,
Okay. And someone applying, they can apply at the same time for both those?
yes.
Anyone else have comments?
I'm just still trying to understand it. It's still kind of complicated.
It's all, yeah.
Yeah, so. And
Yes, it is complicated.
we always talk about this at the end of the meeting when everyone's brain is fried.
You're changing my tactic.
All right, so.
Well, you don't have to vote on anything. I mean, we can just get more thoughts and come back with more language.
I can't even think at this point. So, I think you said from the application date through the date the record closes is what you're recommending the proof of primary residence to be?
So what I said was, ideally, it would be through the date the record closes, from the application date through the date the record closes. The problem with through the date the record closes is, once the person's off the stand, there's no way to get additional information into the record without reopening the record. So you wind up with this situation where you're constantly reopening the record, and you don't want to do that. So our suggestion is, instead of through the date the record closes, it's through the last date that person testifies when they are testifying.
Yeah, I think that simplifies it.
Yeah.
Does
Do they
anybody
always
else?
have to, but I remember in oath, I don't think you have to appear, right? You can just have your.
They're going to have to appear. They're making a claim, they're going to have to appear. I mean, I guess they could say, if for
You
some
can
reason.
appear by your attorney, is that what you're asking?
Yes, that too, right.
Well, but the attorney can't testify for you. I mean, so.
So now they have to be appearing. I'm just saying.
Yeah,
I don't
yeah.
think they had to before.
Can they appear by the record? I mean, with record, like attorney present records?
An attorney can come and present records, yes, but I think in this situation, they would have to appear in person. I don't know that there's ever been an instance where somebody who's filing the claim didn't want to appear. I mean, usually they come and they want to testify.
Sometimes it's a conflict of work, like they're working and they can't take off because there's one date where the course, I mean,
I don't know, they're bringing an application, they should be prepared to prove their case. So
like my husband's a school teacher, he didn't take off work when we went to oath, but.
yeah, but you were there.
I was, yeah, so, but I'm just speaking out for the school teachers.
I come from a family of school teachers.
Are there any left?
And they have a lot of days off.
It's true. Only in the summers.
Starting tomorrow.
So let's just talk about the time lag between the last day the person testifies and the date the record closes.
Yeah.
You're going to be treating people very differently in a large building, I suppose. If you have a lot of people testifying over the course of months or years, someone early in the process is being held to a different standard than someone late in the process. But I'm just trying to understand.
Well, why would they be held to a different standard? Everybody would be held to the same time period. So somebody who in 2010 filed an application in 2010 and had that application heard in 2012, it would be the same 2 years if they file in 2017, right, June 15, 2017, and their application's heard in 2019, it would be the same 2 years. So I'm not sure why that's a different standard.
I think that these trials take place over very long time periods. So different people.
Different cases.
No, different people in one building.
Within a proceeding.
Testifying
Right.
at different times.
Right.
You've got 25
Right.
people.
Right.
the first person finishes testifying
Right.
in year 2,
Right.
and the last person finishes testifying in year 5.
They don't go that long, but yes, that's possible.
Yeah.
Yes, that's possible.
So,
So this kind of helps if they file separate. If they file together, then it's a hindrance. But it,
If they file separately, it
But
could
it-
be helpful, but that's problematic also, because a lot of times people file together because they're sharing legal fees.
What's wrong with just saying to the end of the, when for the record closing?
Because after somebody's left the stand, how do you prove that they're still there? Right, so let's say somebody comes in, they filed in 2017 and their hearing is in, I don't know, November of 2018. And so they're on the stand in November of 2018, but the record doesn't close until June of 2019. How do you get into the record at that point that the person who testified in November of 2018 is still there in June of 2019? How does that get into the record, other than putting that person back on the stand to say, yes, I'm still in? So that was the dilemma that we faced, right? It's-
Would it be up to the owner to raise the bid?
No, because in this case, it is the tenant's application, and the tenant is making the allegation that they want to be protected, so they have the burden of proof. Right, I mean, the owner, of course, could come back and say, well, they're gone.
Yeah, I mean, if the owner doesn't come back, that's almost like consenting.
I don't know, I mean, there could be a presumption that absent something else.
Could we
Absolutely.
put that in?
Well, assuming they're paying rent, is that correct?
I don't know.
Could it-
Well, I mean, I would think that
Not
that
necessarily.
in a lot of Class A apartments, people pay rent for apartments and they're there.
But remember, it's not, Class A apartment yet, right? I mean, it's, right, at this point in time, unless the apartment is already an IMD, right? If the unit's already an IMD, then it's legal for them to be there. But if the PO application is coupled with a coverage application, it's an illegal occupancy until the coverage application is granted. Right? So it's not a Class
Right, I
A apartment
understand
in the
it's not the
traditional
same
sense.
as, but we've all been illegal and living in lofts. Those of us who've been living in lofts. It's all been illegal, including maybe several hundred, that didn't file by June.
June 15,
26th,
2017.
Whatever. So I think that possession isn't
Two-thirds of the vote?
isn't that enough?
Well, but
Whether the
again,
building is an IMD or not,
no, for our issue, it's the type of possession that matters.
right,
Is it primary?
right. And do we know if they're still there, if it's after the time of protest?
How is it being handled now?
So now, I guess they're proving it,
If you are the primary
C, right?
approved primary residence, if you're there prior to the effective date of the law, you don't. It's just, yeah.
I guess
Yeah.
my question is, where
Right.
does the end point of the proof exist now?
You just have to show occupancy.
It would have to be, no. If we're talking about primary residence,
Yeah.
right? So let's assume it's a prime lessee or a sublessor who's not in possession, right? So now, where would the end point be? It would be, I guess, we held in
Yeah, these people were all out. The people who didn't, we found that they weren't appealed, they were all out prior to the effect, prior to the effect of the law, right?
but they were out prior to when the record closed, prior to when they testified.
Yeah, they were already.
They were out prior to when they testified. But I think the decision said, at least the Hughes case said, when the record closed, I think. I don't remember exactly how.
Yeah, I think it just showed that the record showed that the person didn't
Use
use
it
it
as
as
the
a
primary
primary residence.
Right, we didn't make a cutoff date.
Yeah.
Right, the impetus to making a cutoff date is to kind of put a stop in the rolling discovery. That's the impetus to having some kind of cutoff date.
Right, this is something that requires us all to think a little more about it.
Yeah, I assumed you would.
Yeah.
I'm trying to think the opposite, like positively instead of arguing against it. I'm just wondering if a new law did pass, theoretically, does this help incentivize people to apply sooner than waiting?
Yeah,
I would think so.
it would, yeah.
But then, does it get backed up with cases? No, I don't know. I don't know what's timeline.
You know, there's only, when I was there were only 10 of them. I'm not sure how many I think they got funding for a couple more, but it's not a massive court by any
I have a
stretch.
suggestion, since Chuck says that he hasn't read this thoroughly to discuss it. Why don't we discuss this right after your report, the next meeting, rather than waiting to the end of the meeting? As Robert says, we're all a little bit fried. And maybe we can come to some simple resolution early on in the next meeting.
So I'm fine with that. However, I want to make sure that we get the cases done. So, I mean, the cases, I think, are the board's primary
Anticipating a whole
responsibility.
bunch of difficult cases next month, is that what you're...
Who knows? They're always all simple to me.
I know.
We don't want any mandamus.
My wife always asks me how much it would be, and I say I never know.
So, if we want to do that, we can do that and just limit the discussion to X amount of time so that we have enough time to do cases, but people have to be willing to stay to finish the cases.
I think
I think we should prioritize the cases, but I think that, that's just my thoughts, but we should do some homework here now that we have this.
Well, what homework do we do? We could just go home and just contemplate this over and over and over again.
Well,
And I don't know whether we can, just going home thinking about it for the next month, whether it's going to resolve it.
No,
the
not
next
resolve
time
it,
we
but
meet.
I did ask Elaine, I like to look micro and macro, and we've done a lot of micro looking at specific clauses, but I did ask her to provide a one-page summary, which she has, I think you said we have it.
You're talking about for the all of the rules that we've done so far,
And like, if people aren't ready to discuss right now, I'm just wondering, maybe she could go over the one-page macro scale of where we're at, so that we see the big picture too, because we're going into all these single sentences.
So can I just say that I think that we've made more forward motion on this particular rule than we have in the last 2 years. So I'm not necessarily in favor of leaving it and coming back to it. So
Today,
I kind of feel like we're on a roll.
Okay.
And I'd like to keep discussing it until we've hammered it out. No, until we finish this rule and then go to other things. So, we're finally making,
So,
Are you against
so
it?
do you, board members, do you think we can do this in the first 15 minutes of the next board meeting?
personally, my feeling is that I believe the public comes here more to hear cases that concerns them, for one thing, and secondly, if I had to leave out some mental energy for something, I would rather have my maximum mental energy when I'm dealing with the cases that deal directly with the welfare of.
But you will have that option in the first hour, this private session to think about the case and debate the
I
case.
just really don't see what flip-flopping it is. I don't think it's going to make any difference whatsoever. Obviously, I'm a big fan of the separate meeting for rules than cases, so that the board members can focus specifically on, what the issue is. But I think putting rules before cases, It's a concept, but I don't know that I personally agree with it.
Yeah, because it's that 1 hour slog, the first session that's really the tiring thing. I mean, we're still gonna have.
Well, it's really not even only that for me, but I mean, I'm coming in here really right up until the last minute thinking about these cases,
Yeah.
and thinking about these lives that are affected in these cases.
Yeah.
But you've already done your thought in the first hour. Really, the discussion piece is spoken already before you even go into the public.
But you're not as old as I am, Mr. Chairman.
Well, thank you. You just gave me a compliment. I understand. Listen, can we get an extra board meeting then in June to discuss rules? You guys with you access that?
Yeah, but are we again, you're against looking at the one-page summary today?
I don't have it today.
Oh, I thought you had it.
Oh, no. No, I did not have a chance to prepare
Okay.
it, but I am going to. I mean,
So
I
I'd like-
have something, but it's
I mean,
not
it's like that,
updated.
like, big picture, little picture, big picture. Like, we're skipping months and then we're diving
Yeah.
into like a sentence and
Right
I
on
need
May
to see that.
So,
Maybe
yeah.
on May 30th.
I get, it seems like we're getting a consensus here that we're not doing this tonight, right?
I'm not saying that. I'm not against continuing until whatever our time is.
All right. I just want to make sure.
I mean, we could still continue the discussion, but in terms of a vote.
Switch to some
I think
other
we're
topic or something.
Well,
Well, we still have more to talk about on this.
on
day.
this rule, right, we could still continue to discuss
still
this.
Okay, so what's next on this,
Oh.
the next change?
I don't want to leave this section just yet, I still have.
Yeah.
Just 1 second, just 1 second. Are we going to talk about, are you going to table it on the next meeting?
Yeah, okay, so we can consider doing an extra meeting and I'll send around an email to everybody about possible dates. We should actually check rooms too.
Yeah, well, it can't be the first week in June.
Okay, so, yeah,
I just, the chair won't be available, so.
okay, yeah, okay.
All right, thank you. All right, Mr. Carter.
Yeah, I'm concerned about this notion that you could still qualify, for protection when you've had a break in occupancy. This concept of that you're in on the effective date of the law, then you're out, and then you're back on the application date. Having left really, I think, demonstrates that you don't need the protection of the Loft law, because you left, you had someplace else to live. So I don't quite understand why.
So we have people who come in after the effective date of the law and apply for protected occupancy, and we entertain those applications, and we grant some of those people protected occupancy, so,
With the landlord's consent or without?
no, with the landlord.
Oh, of course, yes, with. That I understand. My issue is the without consent.
So you would be in favor if somebody had a break, and we would have to determine how long that break would have to be, right? And came back, that they would be applying as if they weren't there on the effective date of the law, and then had to show landlord consent?
I think so, yeah.
So what you're saying is they could leave and come back, providing the landlord says, okay, you can go for 6 or 8 months, fine. Pay your rent, you can come back. Is that what you're saying?
Are you talking about people with leases or without?
Without.
Without a lease? They would, without a lease, they would have to have the landlord consent to live there?
That's how our rule works now. If you're not in occupancy on the effective date of the law, yeah.
They're just living in an apartment
Supposing,
and they're there. I thought the subtenants, I mean, I know lots of them that just are living there, but the landlord doesn't have anything to do with it though.
hypothetical situation, just supposing I go to the landlord and I say, look, some of my artwork is going to be on display at a gallery in London for the next 3 months. I'd like to go over there and meet with my work. Are you okay with that? And would my, could I come back and live here when I return? And the landlord says yes, okay? When I come back from London with my artwork, the landlord says, you know what, while you were away, I rethought things, I changed my mind, you can't come back in. I'm just throwing out a hypothetical situation, because how would you avoid that if you didn't have some sort of lease? I mean, verbal agreements can be broken, even a lease can be broken, but at least you have a document that. I'd be concerned that.
If you're paying your rent, so there's a couple different, so if someone leaves for 3 months but they pay the rent every month, they're still fulfilling their obligations as a tenant, and they haven't moved, and it's still primary residence because...
Well, if they're away for work, right, I mean, we have cases that say that if you're away for
Or
work, then it
school,
can still be a
or
resident, right,
weeks, right?
right.
Meetings ago.
Yeah, but what if, again, and I'm just being hypothetical. Something goes on and the landlord, while I'm in London, and the landlord says, I get a letter in the mail from my London apartment address or whatever with my last check that I sent him for the rent
He says,
returned, and he
terminating your-
says, you know what, I've decided I want to go a different direction, and, you're not able to come back here. Kind of throws a tenant out in the cold,
And not cash the checks.
Well, right, he returned it, the owner returned the check,
Right.
and said, with the letter saying, I've decided to go a different direction,
But you can
and,
do that anytime, right? I mean, it doesn't,
Yeah,
so...
once the lease is expired.
Was,
I mean, we have had tenants say that they have been tendering rent and the owners have refused to cash their checks.
I'm not against that
Scenario.
concept, but I think there ought to be some sort of document that has to be filed with the Loft board or something that says that the department will be there for that person when they return from their,
Well, the person isn't protected yet. That's the whole point, right? So how could you require somebody to file something with us when they're not even protected
because they're
yet?
not
So you
under
can't.
they're not under
Right.
our jurisdiction yet.
I mean, the other thing too I'm concerned with is if you, let's say the coverage, the IMD is covered, and then you make the bar so high that there's like no human is living in that apartment, so there's a space that's an IMD, but there's no one in it. I don't care about the space with nobody in it. I want people protected, so I'm just concerned when, like, I know a bunch of buildings, on Craigslist, I think people are renting these, and so there'll be a bunch of tenants in a space that are subletting that don't have a lease. I thought they would be able to apply for protection, which, because they're living there. That's the purpose I saw for the law. So when, I'm just saying if Robert's saying that they have to have the landlord's consent, the landlord's kind of, in this particular case, like wipes their hands of, like they're collecting rent from this primary absentee person in another state, so they're still getting the rent, but meanwhile there's someone real, a neighbor in the building. I don't want them thrown out in an IMD protected empty. Like that would be that's counter to the idea of we're supposed to not displace people, humans.
So under just under the current rule, right, so the way that it would work now is a subtenant who came later after the effective date of the law does have to prove consent of the owner to their
Consent of the
tenancy.
owner?
Yeah, so
What
the
is that?
current rule.
They have to get
Says
a
that.
note? What do they get?
Well, I mean, it could be a lot of different things, but usually it's that the owner is interacting with them in some substantive way. They're paying rent to the owner is contacting them for legalization work, they're listing them as affected parties on Loft board applications, so it's not necessarily, you know, it's similar to the factors that we actually listed here.
I'd like to see that better defined, because I see that as a real issue.
Well, we
now.
have, if you look at part 5, right, we put some stuff in there. We had the current rule, hold on. Current rule actually doesn't have a whole lot about it. We decided we should put some stuff in there to give more guidance.
The fact that you need to show consent is really not controversial. What's controversial, I think, is how to show the consent.
Right.
Well, I'm not sure that other people would agree with you there, but.
The discussion of primary occupant is to,
We were trying to separate out the consent, right? So if you're filing, okay, I gotta reread what I wrote. Oh, what we wrote. So if the individual is there using the unit as a primary residence on the effective date of the law, then it doesn't matter about owner consent, right? And then also, but if the individual, I'm sorry, you're not the only one who's been on this one. If they use the unit as their primary residence on the effective date of the law, then we don't have to worry about consent. Other than that, if they need to prove primary residence on the date of the application until when the record closes or the last day they testify if we want to go that way. The current rule reads, when a residential occupant took possession of a residential unit covered as part of an IMD on or after, and there's various dates that are the effective dates of the law. Such occupant is qualified for protection of Article 7C if the occupant is a prime lessee with a lease currently in effect, or if the occupant took possession of the IMD unit with the consent of the landlord as a statutory tenant without the issuance of a new lease, or the occupant is the assignee of a prime lessee and such assignment was consented to by the landlord, or prior to establishment of such occupancy, the landlord was offered the opportunity to purchase improvements pursuant to 286(6) of the MDL and these rules. So that's how the current rule reads.
Well, I understand what you just said, and actually was very interested in that. Inasmuch as the landlord is accepting the rent from the tenant, isn't that consent?
Well,
Could be construed as consent.
well, the redraft lists that as one of the considerations for the board in terms of determining consent. Yes.
Is that now enough for us? Do we
Well,
have
no,
to-
because you've got to have people that aren't there that are paying rent. Like, we had the case last month where the person was paying the rent to somebody in Maine, and then the Maine person was, the person in
but
Maine
we're
was
trying
paying
to
the landlord.
dissuade profiteering and other,
Yeah, I agree.
So so it's a factor, but I don't think it's the only factor.
All right.
There's a lot of that, I think, that should be. If what he's saying, like if you could prove by absentee mini landlord that the rent is being cashed by the landlord, that person who's currently living there, that subtenant, even though they didn't pay the landlord direct, the rent's getting paid through that other person. I mean, is that consent to?
To the
The landlord's
subtenant?
consenting, he's not showing up at the door and saying like.
Well, I mean, if we take the case from last month, where you had, oh, maybe we shouldn't because it's pending, but, I mean, well, actually, they're still, yes, right? They didn't go through consideration. Right. I mean, if you take that hypothetical, or a hypothetical like that, so they're there, but they're paying their rent to somebody in Maine, and then that person is paying the landlord. But the landlord is knocking on their door and saying, I need to install ductwork because I have to legalize the building, and they're the ones that are letting the owner in, right? So they're interacting, they're substantially interacting with the landlord in that situation. I think that's another way to show consent, and I have that.
Elaine, how is that possibly consent? That's interaction is a forced interaction where the owner has no choice. That's consent by accident. Consent means
I don't know.
some sort of purpose in your mind. I mean,
But if the owner knows that they're there and they're not supposed to be there, and the owner is taking no legal action and is collecting rent from a third party, and I don't know, I mean, there are cases,
well, maybe that could be coupled
We
with
have
other
cases.
facts, but that fact on its own cannot possibly
Which is
demonstrate.
why-
Here's another hypothetical based on a truth that I know. Landlord being present, having his sprinkler guys come in to do a survey to check the sprinklers, and letting them in, and they're having a discussion. I mean, I guess I should have snapped a photo if that counts. But I don't think anyone takes a photo because it was like a boring photo of people like looking at sprinklers. But in effect, access is gained. There's an interaction between the person who's sleeping there and living there and the landlord, and bringing in this entity, and they're in the apartment, and I'm mediating and standing there for half an hour making sure everything's cool, but I witnessed it. Does that count as consent? No.
The two are, now we're getting, this is a little
So-
because
I don't think so.
No, but you could also imagine a scenario, have you never like gone to your friend's house to let the plumber in? Or the cat sitter, or, I mean, people let other people into spaces all the time for all different reasons.
No, but he went in my apartment. I spent an hour with them, talking to them, and then
But
I
how
went to
does
the
he
next
know
door
that it's
apartment.
your, like, so you said the landlord's
So the
sent
landlord
a
called me and
sprinkler.
asked for access.
Yes, and somebody was there to let a contractor in. There's nothing in that says that is the landlord, that the landlord's contractor has some knowledge that the person letting them in is the primary resident. Like, that's a stretch.
Why? Because they're going in their bedroom.
That's a stretch.
They're going in their bedroom.
Yeah, so
I mean, I just like, I find that totally rational.
Too much respect.
Too much of a stretch that
But
they're
wouldn't you
in
say
your
it's-
apartment.
But wouldn't you say it's a factor? Maybe it's not alone, but shouldn't it be a factor?
But not on its own. Yeah.
Well,
Knowledge
nobody's saying it
is
should be on
supposed
its
to
own.
knowledge and-
Well, Elaine, your example was actually had actually isolated that factor.
Sorry,
And
I agree, it should be on its own.
And as drafted, that factor alone would hold up. It says consent may be shown by
Maybe shown,
by any of the following.
right.
Yeah, so that's a problem, I think. Anyway, it seems to be 4 o'clock.
And that was just getting interesting.
No, I think it's
Everyone woke up a little bit.
Just starting to get us.
It is daylight.
Luke and I were just starting to get
I do
our.
shredding all the time. I can
I
stay
think it
here
was
all
that piece
night
of
if
chocolate.
you want to work this out.
I can't. Sorry,
I'm
Julie.
game for working this out, and I'm serious, like, how many meetings do I have to sit in? Let's work this out. We can't just be tired.
Well,
It's not fair.
It's the end of the day.
It's not fair to the people.
You got here late, so please, be in that way for you.
Only a couple.
No, please.
Okay.
That was a private
Guys,
meeting.
This is,
It wasn't for the public.
yeah.
Julie, it's a
I
big
agree.
holiday week.
I actually agree with
We
Judy.
really need
Let's
move
try
on.
to press on a little bit here, all right? She's right. Okay.
So,
Let's have some part of this, right?
all right.
Let's do it to the public.
I feel like, I'm not a lawyer, but I think what Julie's saying is a factor that's legitimate. To me, that is implied consent. There's an implication there that the person is, you know.
I can
Should
start.
that be the only thing? I don't know. Maybe
Implied
there should be.
consent, because the landlord chooses not to take action to remove somebody is.
No, the landlord is taking a rent check, and somebody at the apartment is letting contractors in to do work,
Well, if it's the same person, it's one thing. If it's a different person, it's different.
what do you mean if it's a different person?
Different person who's actually paying the rent, and
Well, what happens if it's,
Well, who would go around, who would pay the sprinkler people to come but the owner?
what happens if it's the 18-year-old kid?
tenant side.
On the tenant side.
What happens if it's the kid of the primary
So
tenant?
Joe opens the door, Steve is paying the rent, and now Joe is claiming protection merely by opening the door. That's the issue.
Yes.
Guys, we agree.
I disagree. I actually live in this scenario, and these are my people that I see all the time. So I know the scenarios, and I think if we make a law that doesn't deal with reality, that we're allowing like loft law to keep extending, and you don't protect people. The point is to protect people in these buildings,
The
not
point is
to
to
let them
protect
keep living
qualified
there.
people,
Not
not
to-
any people.
Yeah, but they keep living there, and if they're not protected, that's not a condition that I like. I would like the rules to be improved so that the people actually living there, who really live there, get protected.
And I think that's what we're trying to do. We
Well,
just have to
Really
figure
living
out
there is
how
not
to
the
phrase it.
standard.
Okay, so in,
But I'm sorry, but the flip side of that we've been talking about is if, so what Robert just said is if the subletter then applies for protection, but the flip side of it is if in that same scenario, the prime, well, it's not a leasing, but who is it, Steve and Joe? Steve. So if Steve applies for protected occupant, then the person who's actually living there, A, loses, and loses twice because they're getting overcharged and they get evicted. Right?
I'm not,
only if Steve is not living there.
yeah, I'm not.
Right, all right, Steve lives in Maine. He pays $1,000 a month, but he's charging Joe $1,500 a month. And then he decides he wants to move back, and he says, sorry, Joe, you're out. I'm the primary resident.
Right.
I want to be the protected occupant. I'm taking back my apartment, and thanks for the extra $500 a month for the last 5 years. Like, that's another scenario we're trying to avoid, right?
Yes.
Would you not agree with that, Julie? And
Yeah,
then-
we are,
and
we're
then
trying to
someone's-
protect people living there, but I don't think
But then
letting
that-
the landlord decide.
But that's the person, so, you know,
Well,
the
that's
person who's
the
taking the
consent.
rent and then paying the rent is the one choosing to, then the landlord's not doing the eviction, the renter's doing the eviction.
I just don't want the rule to read so that we have empty physical spaces with no people in them because we're being so hard on what the bar is to prove that you actually live there when you do live there. If none of you believe that that worked except for Richard Roach, he thought I was making a stretch when that's like my reality last month.
No, I didn't think you were.
No, you were on my side, but everyone's like acting like I'm wild and crazy. That was a real scenario. Should I have filmed the whole thing so that then there's proof in court for them?
Well, actually, in additional defense to what she's saying, whether it's the law or not, my experience is that in some of these loft buildings I've been in, it's very much like a family setting where everybody knows everybody, and you know that there is a lot of cooperation amongst those that
Communal living, yes.
live there. Well, I don't, you know,
Well,
I mean,
it was 20 years ago.
the point is that I can see a Steve letting a Joe or Sally or anybody else in and out of apartments, but I mean, ultimately though, if somebody comes there to do sprinkler work, they're not hired by, well, I guess they could be hired.
They're just surveying the sprinklers, yeah.
I mean, I
Service.
Surveying.
Or surveying, okay.
Taking account.
So let me ask you this, Mr. Carver. You don't like the language consent may be shown by any of the following, right? We can change it to what's similar in 6, although no single factor is solely determinative. Factors for the loft board to consider
in determining whether the owner has consented, include but are not limited to, which I think seems to be where the board is going. Yeah, you could consider this, you should consider this, it's a combination of things.
It's certainly better than it exists, but I really think more thought needs to go into making sure that consent is shown by the intention of the owner and not an accident. And that's...
Well, these factors are based on board cases, right? I mean, these are based on cases that the board has decided.
Well, we can still think more
How
about
do you
it.
show owner, and how could you show intent though?
Did you say owner intent? Did you use the word intent?
Yeah. All right, over the next month, I'm gonna talk to people who are in the trenches, who are at these hearings, who have dealt with these issues before, and I'm gonna get their input, and I'm gonna come back with some more input.
Okay.
Okay, that's fine. I think we should not say apartment, but this is a loft board. We should say loft rather than
Unit.
apartment.
Unit, we usually say unit. Did I say apartment? Where
If
did
I
I say?
said,
Okay.
maybe I said apartment.
Well, but so did, that's who wasn't.
Oh.
Anyway,
Sorry.
okay,
Unit, I am the unit.
okay.
I am the unit.
Well, however, you did say a Class A apartment earlier.
Yeah, it's not a...
No, I said it in reference to,
What do you wanna say
to
now?
non-loft buildings.
Yeah.
Okay.
Okay, I think we will, recognizing that this is a drain right now, and it's after 4, we're going to close the discussion. Is that all right?
Yeah.
Mr. Chair,
Do you need a motion?
Can I just squeeze one more thing in here at the tail end? So I know we've talked about this in the past, and I feel like this is somewhat of a residual prime example. I think, and I don't know how we accomplish it because we're a few, but I think there needs to be an educational component to what we do here. I know Julie and I have talked about this. And I think there needs to be an educational component somehow coming out of the law board where we make educational material available for tenants and owners alike on how to deal with certain situations. And maybe the time to do that is after we get the rules established, of course, so we don't put out material that is contradictory to what the rules are that we write. But somebody made the statement earlier, and I don't know who it was, and it's a true statement. You know, we sit here as people that have a background in IMDs and loft buildings and the law, you know, but it's not really the real world. There's people out here living in these buildings that don't understand all of these components and rely on people like us as professionals, whether it's because we're architects, we're attorneys, or fire safety people, to make information available to them on how to avoid pitfalls, how to avoid problems. So I'd like for us to keep that in mind, and I'm not saying we have to do it on anybody's clock, but I think we should look at that in the months to come.
Richard, you were so right. I attended 3 or 4 mass meetings on the rezoning of Soho and Noho. You knew what they was. Most of those people that have been living in Soho don't understand the law. Sometimes totally misinterpret what it is and what it means. So not only are you correct about this, you're also correct that people, loft dwellers in Noho and Soho, don't know what the law is. So I don't know how we can make this thing better known to people, but
I think it's something we need to work on.
but it's a problem in the city, particularly with the expansion that's going on with the law.
Well, I can tell you one thing, that most people in the city live in multiple dwellings, and
most of them would not understand what multiple dwelling law is, right? I mean, that's if you're asking the Loft board to go on some kind of educational campaign, you know, to do that, I mean, certainly we can try to, but that's not, you know, there are
I'm not saying-
organizations for that.
I'm not saying it should be the onus that even should necessarily just be on the staff. This is something we'll have to explore. You know, please don't misunderstand me, but we live in a day and age of social media, Facebook pages, websites, you know, YouTube videos. There's no reason we can't come up with some sort of snippets that we can put out to people to help avoid pitfalls that may prevent, you know, some of these things. And again, I want to stress, for owners and tenants alike.
Fire department does that.
Well,
What is the position?
Fire department has a lot of funding to do fire safety campaigns. Yes.
What is the city, I guess it would be the city's position on board members talking to different groups, community board groups or tenant organization groups or,
I would think it's welcome, except you can't discuss cases.
In cases.
as long as you know.
That's always the biggest problem, because you go with the intention of, you know, I'm just gonna do a general presentation, and then everybody comes up to you at the end and says, well, what about my case? Here's my case, talk to me about my case.
It can be done in a very cautious manner, because now you're maybe violating some law board rules.
So ladies, we have our homework tonight.
No, but if someone, you know, if a member of the board wants to, you know, I'm sure, I hope I don't speak out of turn, but we'll come up with some stuff to present and say, you know, hey, listen, here's something that that would help educate. Education materials, and we're welcome to engage our, the Department of Buildings press office or so to help us to do that.
And I should clarify that anything that we come up with, I believe should be vetted through.
Sure. I would appreciate that, yeah.
Our attorneys, so that we aren't doing something.
Through the Loft board.
Yes.
I think they need to know where we would be doing it, what we would be doing, and that it should be vetted. I think we need to do that. Anyway, Mr. Barowitz wants to go home. Mr. Carter needs a cup of coffee. And I need one too.
Ms. Roslin wants to.
Okay, very good, that's my cue. Okay, so it's Good Friday, Passover, and Easter, right? Wishing everyone a happy holiday weekend and season. This will conclude our April 18th, 2019 board meeting. Our next public meeting will be held on Thursday, May 16th at 2 p.m. right here at 22 Reed Spector Hall. Board members, please sign and hand in your attendance sheets. Thank you very much. Have a good holiday weekend.